All right, everybody, welcome to Better Call Paul. And on behalf of Trident Title, Performance Title, and Synergy Title, we want to welcome Mr. Paul Krasker. Thank you all for joining us right on the verge of a holiday weekend here. And the reason we didn't want to cancel this, honestly, is because this has been coming up a lot. So we've had a lot of mineral right issues passing through all of our different title companies and branches over the last I don't know, I would say it seems like 6 weeks or 2 months that it seems to be crazier than normal. And it has been costing buyers money and sellers money and real estate agents money and brokers money. So basically what we wanted to do is get Paul on here, kind of give a little beginner overview of what we need to know about mineral rights, what's important. And then also at the end, we'll leave it open as a forum for some questions. So if you have any questions, feel free to type them in the chat. I'll get them asked at the end. We're going to let Paul run a little bit. And then I also want to get Gab on here because she's kind of been dealing with it boots on the ground a little bit. So if she has something to add, she's really been the one dealing with it a lot. And I know Deanna and Pat and Kathy are on here too. So all of you guys, we have some processors and closers and stuff on here too that have been seeing this stuff boots on the ground. So at the end, I'm going to open it up to them if they want to add anything in there as well. But Paul, thank you for being here right on the verge of 4th of July. Take it away.
So I've been asked to speak on a couple of different topics for this. The one specific topic that I was told to cover is oil, gas, and mineral rights, which are OGM, referred to in the title industry. And I'm going to use that as a basis to talk about the larger framework of title insurance and B2 exceptions. So let me step above that first and start talking about why I always encourage people to have attorneys do buyer representation as opposed to realtors trying to jump in and answer questions about detailed, complicated title matters. So the agents who were involved in these couple of oil, mineral rights, gas issues, when you start getting into that, the first thing you need to say is, listen, we have an attorney associated with our title company. If you want to have a conversation with them, happy to have you have a conversation on the phone. They're not going to charge you anything for a 10-minute call. But if you're having these calls more regularly, it's really appropriate to turn back to somebody and say, I'm not an attorney. I don't feel comfortable telling you what B2 exceptions are and how they could impact your use and enjoyment of this property, and I want to refer you to somebody who's willing to do that. I charge $750 to do a buyer representation. It takes you out of the bullseye on your back for these kind of issues, and I encourage you, if it's not up front, it should be when these types of issues occur, to hand those people off to somebody who can have a detailed conversation and work something out that makes sense for everybody. That said, we had situations where other title companies, number one, weren't providing all the B2 exceptions to the purchaser. They were just sending out a title commitment without the B2 exceptions. Well, the contract specifically states that you need to send them the title commitment and all of the B2 exceptions, legible copies of all the B2 exceptions, and the buyer's right to object to title doesn't stop until 5 days after they've received that. So if you're a buyer and you're trying to delay a closing and you didn't get the B2 exceptions, guess what a guy like me does when the buyer comes over? I said, did you get the B2 exceptions? No, I didn't. First thing I do is write a letter saying, I'm sorry, I don't think you sent us the B2 exceptions. We have 5 days to review those and to object to any of them. And then you'll have an objection period of 90 days to go fix it. So that's one reason why our title company is required to send out all the B2 exceptions at the same time that we send out the title commitment. And what happened in this particular circumstance is that when the title commitment and the B2 exceptions were received by a third party, there were some oil, gas, and mineral rights that were reserved to a third party on the title commitment. And of course, as you'd expect, right before closing, the buyer objected to those and said, we don't want a property that has oil, gas, and mineral rights reserved to some third party. Again, keep in mind, this wasn't our title company handling the closing, so we weren't intimately involved in the resolution of the issue. But usually that takes the situation of the seller having to go back, contact a third party, ask for a price for the release, getting the price for the release, and then turning back to the buyer and say, if you still want to have a deal, we're going to split this cost, or I'm just going to cancel the contract and move on. So that's in general what had happened, and why we say it's important to make sure that you are working with a title company that does deliver all the B2 exceptions to the buyers. And I think I probably handled that well and said enough that no more needs to be said on that issue. I do want to take everybody through the mineral rights, or the oil, gas, and mineral rights, just so you understand what those are in general. Again, I'm not trying to educate you to a level that you should be advising clients on these things, but just enough so that you should understand the issue. When people separate the surface rights from the mineral rights, that's separating out the estate into two separate estates: the submerged land and the surface land. And there were some companies, Southern Timber, Florida Timber, Community Real Estate, a couple of others, that reserved rights for 50% of any oil, gas, and mineral rights under the land. So when they'd sell off a parcel of property to a developer to build a 60-acre community, they would reserve the mineral rights underneath it, thinking that they'd eventually get paid someday for those mineral rights for anybody who wanted to take it back. Or if they owned the adjoining land, they could suck out the oil and the gas through techniques like fracking, to, if Florida allowed the drilling, that they could drill in the adjoining property and suck the mineral and oil and gas out from there, and share 50% with the owner and keep 50% for themselves. So there were a lot of people who did reserve mineral rights, and there are a lot of companies that have gone and bought up those mineral rights from the original owners and are now trying to blackmail people to pay them for the mineral rights. And some of them even go so far as to say, great, well, if you don't want to pay it, that's no problem. I'm going to send a drilling crew in, and we're going to see if we can find some oil in your backyard. Does it ever happen? No. Usually the people work out a solution by then. But that's sort of the concept. Now, I want to explain that there are private mineral rights and oil and gas rights, and public oil and gas rights from the state of Florida, from the Everglades Drainage District, from all of these other governmental entities. The governmental entities, if it's a parcel that's 20 acres or less, those governmental entities have released their right of entry. They cannot come on your land to drill for oil. So even if there is a reservation, it's only in the case that you decided to drill for oil on that land. So if you're buying a residential parcel out in Wellington and you're going to use it as a second home or as a primary residence, and as long as you don't intend to drill for oil or minerals or gas, then you have no worries if it's a public reservation. The only time you'd ever have a worry is if it's a private mineral right. And many times, a law firm is able to go to the title underwriter, even on those private ones, and find a way to have the restriction eliminated altogether. There's an act called the Marketable Record Title Act. I'm not sure if you've heard of it in real estate school. Many people refer to it as MARTA, M-A-R-T-A. But that Marketable Record Title Act is one where if there's a root title going back 30 years and this document was before that root title, we can just simply turn back to the underwriter and have them remove that reservation. Now, there's a whole bunch of complex rules. If it was referenced in another deed, or if it was, if there was an intention to reimpose the same within that 30-year window, then it continues for another 30 years. But there are all these tricks and tools that we can use as real estate attorneys to try to eliminate that private right before a seller would have to negotiate. Ryan, do you think I've covered everything that was intended to be covered? Is there something else that people were wanting to know?
Yeah, I know we have to kind of be careful with what we say about, some of the issues that had came up, but I just think it's important that they understand a little bit about how, one of those closings went so sideways, just so they know what kind of happened. And Gab, I was talking to Gab a little earlier this morning. Gab, if you're on, if you want to dive in here too, because I know you've kind of seen some of this stuff and been dealing with it. So, or even Deanna or anybody that or any of the closers, just to kind of help people understand why the agents have to worry about this. Like, you did a good job saying that, they really should just hand it off. But I know there was a case where it cost the agents some money that they had to split a bunch of commission because they didn't do anything. So I don't know if you can talk about that a little bit maybe, or Sophie, if you have anything, or Anna.
Yeah, that's what I was going to say. Can you hear me, Ryan?
Yeah, go ahead.
So yeah, I would invite, even Sophie to jump in with any questions. I think Paul did a pretty good job. I would say the only things I might ask for a little clarity on are, when we're talking about this is costing, Paul, I know you're saying if there's a party right, they have to contact the third party and get a payoff and everything. Can you go into a little more detail on that? I've heard the number 2% floating around. I don't know where that comes from. I don't know that we all know exactly, why or where this, these payoffs are coming from, and how the figures are being determined, and how are the agents, how should they be proactive in making sure that these unexpected payoffs don't come up at the last minute in the course of the transaction?
Yeah. So I don't think it's the agent's responsibility. I'll be very clear about that.
Well, right. So maybe I should ask us from a title, who I guess, what do we all need to do to, make sure that this is handled correctly? I mean, on our side, we're going to send out the B2s, but I just want the agents to be very clear on who is responsible for doing what. What is the title company responsible for? What are the buyer and seller responsible for as far as their due diligence? I mean, is this something where if it's a property that they may run into mineral rights, they really need to just get an attorney? Or, I think that's where a lot of this came to be, is it was kind of like a lot of finger pointing where, this person should have done this and this person should have done this. So, say that there are mineral rights on a property. Who's responsible for what in order to,
Okay.
does my question make sense?
So sure. So let me take you through the timeline of the contract. Within 5 days of the effective date, the listing agent should be asking the seller, and really they should ask it before then, does the seller have a copy of their existing owner's title insurance policy? Because that's required within 5 days of the effective date to be sent to the buyer if the seller has it.
A question, isn't it the title company that's gonna request that?
Well, usually you guys don't give us the contracts until after the inspection period is over. So if the inspection period is 7 days or 10 days and we don't get the contract until after the inspection period is over, then the seller has already breached that obligation to hand over their existing owner's title policy because it's 5 days from the effective date.
So, sorry, Paul, but the problem that we had is we had the title policy, but we didn't understand what they meant because it's not clear at all. You know, there's a lot of bull, you know, for the mineral rights, but, you know, it's not something that we know. And
Okay, so we're talking about two different things though.
Okay.
You're talking about the title commitment that the title company prepared, but that's done, you know, closer to closing. That's done if it's a mortgage deal 15 days prior to closing, if it's a cash deal 5 days prior to closing. I'm talking about the prior owner's title policy in favor of the seller. And that's something that you guys as agents should be asking about when you sign the listing.
Yeah,
By the way,
Nancy just made a good point with that too. Like agents, that should be in your listing appointment. You know, once you get those documents signed, that's one of the things that you're collecting on day zero, you know.
to say, great, I need the name of the management company, I need the prior survey, I need the prior owner's title policy, so that you can be handing these over within the 5-day time period under the contract. So if you're, and Sophie, if you're going to give us the contract immediately upon execution, we're happy to reach out to the seller and say, do you have your old title policy? But that's a heck of a time to ask them because you have to get it to the other side in 5 days, and it might be up in New York and they're down here or vice versa, and they might not have it. So best practices, as Nancy said, is to get that in your hands before you're even marketing the property. And that way, immediately, you can hand it over to them. Now, if you have a buyer that's going to take review of title seriously, then you have to stick to the very strong letter of the contract. And the contract says that the seller has to hire a title company that's going to deliver the title commitment plus all the B2 exceptions to the buyer 15 days before closing if it's a finance deal, and 5 days before closing if it's a cash deal. And then the contract also says that from receipt of that information, the buyer has 5 days to make an objection. So if you really want to resolve these matters quickly and know that you're going forward with a closing, get it to them as soon as possible. You don't have to wait until 15 days before closing. If the inspection period's over and you want us to run title and it takes us 4 days to run title and it takes us an extra day to get the B2s and send it off, that's 5 days after the inspection period. You've got title over there. That could be 30 days before closing. Now we've got title done. We're happy because we get to look and see if there are any issues that need to be addressed that might take some time. Open permit, liens, other issues, 3 mortgages that weren't released, whatever crazy stuff happens that you guys don't even know happens that we fix on our time period. But that gives us more time to look at it. And frankly, it starts the buyer's time clock ticking. And if the buyer doesn't hire an attorney until 5 days before closing, and you've sent them the title work 30 days ago, and the buyer writes a title objection letter and says, we want you to release the mineral oil and gas rights, turn back to them and say, no, we're not doing a thing. We sent it to your client 20 days ago. They chose not to hire you. We don't have any obligations to do anything. We'll do all these other things for you because they don't cost us any money, but those oil, mineral, gas rights, you bought them. That's it. You took subject to them.
Yeah, but isn't it the title company responsibility to sort of point it out to us and say, hey guys, there's something very different here. Because us, we get the title commitment and the title, and it sort of explains to us if there's a lien and everything, we can point it out. But nobody pointed it out, and I don't know what to, this product with this long with blah blah blah.
So I'm caught in a tough position, Sophie, because number one, I don't say bad things about other title companies. I just don't.
I'm saying general.
So, but I think that's the reason why. I think that's the reason why Trident has 2 staff attorneys that are available to people. So if our closers or our processors see something that's out of the ordinary, and that's a concern, they can raise it to the seller's realtor and say, hey, listen, I'm sending the title over, but I'm a little surprised that there's this, this, and this on there. That's not customary for this transaction or this community, and I'm a little surprised. We'll send it over and we'll see what happens. And if 5 days go by and the buyer doesn't object to it, we're okay, we can close. If 5 days go by and you get a letter from an attorney that says we object to the oil, mineral, gas rights, it doesn't really help you too much to know about it 5 days earlier, but at least you don't feel surprised. Does that make sense?
Yeah, but I'm still pissed off.
I don't think there's anything that I could say to you that's going to avoid that right now.
Expensive lesson, let me tell you. For me and Marsha,
Yeah, there's no question, and again, getting us the prior owner's policy is something that helps suss that out early on as well.
So do we give it to the title company, the prior, or do we give it to a lawyer?
Well, you give it to the title company.
Okay.
So if Deanna is working a file and you know that the inspection period is coming up and you've got the prior policy and you send her a copy of the contract and the prior policy and the survey, and you say, please get started on this, the first thing she's going to do is look at the prior policy and see if there's something strange. And she's going to order an update to see if it's changed, if somebody's fixed what was on there. But yeah, that's part of the discourse between the title company and the agent, is to say, I think we have a problem here. Keep in mind, there are a lot of very bad title companies out there. And one of the things they do horribly is they just put reservations in deed recorded in OR book 1238, page 642. They don't tell you what those reservations are. They don't tell you whether they're important or not important. And that's why I always say, I can't believe how many agents don't have a buyer hire an attorney to look at the title commitment. You don't know what you're taking title to. I've had titles that I looked at that had an easement running through a swimming pool. And you just say, listen, if you're going to hope nothing happens, that's fine, but at least we should have the seller require a non-removal agreement from the easement holder. There's no reason that the association would have allowed them to build this pool in their easement if they cared about that easement. So let's get it removed from that. There are a bunch of things, not just oil and gas rights, but a bunch of easements, reservations. Many times it says you can't, you can't do a secondary structure, and somebody wants to put up a pool house in the back, and you showed them the house and they told you 15 times, oh, we're so happy, we got an acre, we're going to put a mother-in-law's quarters in the back area. and we're so excited, and then somebody comes to me to do the land use, and I say, it's restricted. You're only allowed to have one structure on that lot. And now all of a sudden we've got to try to build an annex from the main house with a roof, open air covering, so it's attached to the main house, etc. And then those people come back to you furious because you told them what you wanted to do and they couldn't do it in the end. So those are the kind of reasons why I keep encouraging agents to hand off that buyer representation.
And we're going to do a whole session on that too coming up about that buyer representation, because I think that's important too, that people know that and understand that, the ins and outs of that as well.
One of the things we do when we get a buyer representation is we turn back to people and say, are you making changes to the house? So that we can have the setback lines put on the survey so that people know what it's going to look like and where their build envelope is, so to speak, as opposed to what it looks like today. Anyway, I sound like I'm pitching for myself for work, and I'm really not. But I also don't want you to sit there with a bullseye on your back and have your clients angry at you for something that's totally beyond your control.
All right,
can you get a little bit, can you segue with that being said, just a very like a 30,000 foot view of the difference between like B1s and B2s and what a title company, like what's considered clear title, from, what's considered clear. I think there's not a lot of clarity around what is actually considered like a title defect and we can't close until this is resolved versus this is a B2 thing, but it's not considered a title defect. Could you just give like a brief overview of the difference there?
Yeah, and unfortunately, it's a gray area. There are some things that are black and white, but much of it's gray. Like this oil, mineral, and gas rights. Could you close without resolving the oil, mineral, and gas rights? Sure, you could live 20 years in a house with somebody else owning the subsurface rights. And as long as they don't try to enter and drill for oil, you don't care and don't know about it. Do you want to do that? That's a decision for each buyer to make on their own. There are many buyers who don't even care, didn't even look to see whether there was or wasn't something there. And at the end of the day, it never bothered them during their ownership. And I'm sure this seller, whoever this seller was, said, hey, I owned this for 8 years. It didn't bother me. I don't know why you're crazy about it. So those are the gray areas. But there are other things like a mortgage that people forgot to record a satisfaction of mortgage, a lien on the property from an HOA or from a utility or from a contractor. Those things are black and white. Those need to be fixed before you go to closing. Other things are land use related, like I was talking about before with the ancillary structure in the backyard. There are some communities that say you can't have it. It's one structure per unit. There are some communities that say you can't have more than 3,500 square feet. There are some communities that say you can't have less than 4,000 square feet as a house. So some of those get to be title related. Others get to be land use issues that you can close and you're just subject to whatever the documents say. But yeah.
All right, a couple questions that popped up that are pretty good here. So one of them is kind of a two-parter. Are mineral rights something that is only related to purchasing to land? Is this something that they need to be aware of for just a regular standard residential community? Is it like a specific area, or is there a way to say, okay, I'm going to run into trouble on this because it's in XYZ area or a certain size?
Yeah. So there was one company out there that had an easement that ran through a bunch of residential developments that that they challenged the existing law and they won. And so their easement was reinstated. And they went to all these communities and said, pay me $1 million or I'm going to start using my easement. And people had to resolve it. It was really the title companies at that point that kicked up the money to get the issue resolved.
So is there something an agent should look out for? Like, is this, I know our issues have kind of been in the Wellington area, but is this a Wellington and Western communities issue exclusively, or, are there certain
No.
areas that you find it happening more or less?
Yeah, most of the time it was the Western communities because those were the swamplands that people thought might have had oil and gas. And as development headed west, sometimes a developer would negotiate to remove the oil and gas rights and pay a decent amount of money. And other times they'd say, oh, I don't care about that, leave it under there. Sometimes they just negotiate to remove the right of entry and let them have their gas rights, but release the right of entry so nobody can come onto your property and drill at that point. So what if they're in existence, they can't do anything on your property to impact your enjoyment of it.
Got it. Are there specific references on the contract to mineral rights? Like, is there something, a specific section or paragraph or page or something that agents really have to understand and know about, or?
Yeah, I mean, there's a few evidences, there's a few statements about title. It's 18A and 18B are the two keys. Basically, you take subject to matters common within the subdivision. So, you could argue, hey, listen, everybody in the subdivision has mineral rights, and it specifically says in paragraph 18A1C, subject only to the following matters: outstanding oil, gas, and mineral rights of record without right of entry. So if the right of entry has been removed, either because it's a public body and it's less than a 20-acre parcel, or because it's private and somebody has previously negotiated for the removal of the right of entry, or it can be eliminated under MARTA, then you're fine and you just move forward. If it isn't, and the mineral rights exist, notwithstanding MARTA, notwithstanding somebody's attempt to previously remove the right of entry, then you've got to negotiate for a price, a release price.
Got ya. All right.
That's where it's located.
Got ya. Okay, one more good one. I asked my client, basically this is about the previous title policy. So I asked my client to give it to me, but they had no clue where it is, lost, divorce, whatever happens that they don't have it. So in those 5 days, they don't have it, they can't find it. Is there something that the seller can do? Is there something that we can do as agents to help them? Is there something the title company can do? Like, what do they do if they just don't have that previous policy?
Yeah, so you don't have to make one up, but if you have it, and I'm just looking for the language.
Because I can see that happening a lot, right? People move a lot, or they get divorced, or they have two houses or whatever, and they just don't have it.
Yeah, it says if seller has an owner's policy of title covering the real property, a copy shall be furnished within 5 days of the effective date. So if you don't have it, you don't have to send it. But again, if you're trying to identify issues as quickly as possible, when you send that owner's policy over, if a buyer says, hey, by the way, there's mineral rights here, and I want to see a right of entry being barred, you've got to do some research quickly.
So is this also kind of a push to make sure the transactions get turned in really early to title so that we know, on day 1 or 2, we're already searching and looking and working these? Or?
Well, here's the funny thing, and we've always had realtors who want to hold on to the contract until after the inspection period. They don't want to waste our time, which is very nice of them, and they don't want their seller to start spending money on stop letters and things like that until they know it's a hard deal. That's all well and good, but we would prefer to get the contract earlier so that we can order an update. Even if that one particular deal dies, you've still got the listing. You're still hopefully going to sell it in the next few months. And these title searches last for 6 months. So let us get it started. Let us find out. Like Sophie was saying, my God, if we can tell you 2 weeks into to your listing that, hey, there's a real problem. I know you've got this contract. This contract might not go forward, but more importantly, we've got to go to South Florida Water Management District and get their dock permitted because it's not permitted, or we've got to go do something else. Give us that time while you're marketing that property to try to help the seller.
Yeah, and then Nancy had a good point too. Couldn't there be a little discount if the seller has the prior policy, so like a reissue credit?
So there is a discount if it was within 3 years and they have the prior policy. It's not a huge discount, but it's worth doing. The value of it, from my perspective, much more so than that little discount, is if I have a prior policy and it's 5 years old, I don't have to go back 30 years on my search. God help us if I have to go back 30 years. That's how some of these problems get on the policy to begin with, because you have some sharp examiner at the underwriter's office who catches something that the last policy guy didn't even catch. Now, all of a sudden, it's your problem. If you had the prior policy, they wouldn't have gone back that far. They would have only updated it from 5 years forward and used the prior policy as the guide. So for me, I get lucky when I have a 5-year prior policy, because I know I'm not letting some really bright examiner go back and have a whatever it is, a cavity filled, where they're just drilling for no reason, just trying to find something for 30 years back.
Makes sense. All right, last chance. Any questions on mineral rights before we head for the 4th of July weekend here, folks? Going once, going twice. All right, folks, if you haven't already, get registered for Monday. We have a database class with a great giveaway to help you add 200 people to your database essentially in one day. So if you want to be a part of that, please make sure you jump on that. Everybody else, as always, thank you for all the deals you guys send to Trident, Performance, and Synergy. We appreciate it. Hope you have a safe, healthy, happy, and fun 4th of July. Stay safe, stay away from the Rona, and we will see you.